Chairman Fairntold, Chairman Palmer, Ranking Member Plaskett, Ranking Member Demings, and members of the subcommittees. Thank you for inviting me to appear before you today. My name is Darcy Helmick. I'm a fourth-generation rancher from Idaho. I ranch with my parents and my brother, and my grandparents and extended family also ranch in Idaho, where they have done so for more than 100 years. I'm following along in those footsteps. I recently bought 30 of my own cows, and I'm working with my brother on transitioning into more responsibility on my family's operation. Professionally, I'm the land manager for Simplot Land and Livestock based in Grandview, Idaho. In that capacity, I oversee grazing permits in 4 states, Idaho, Oregon, Nevada, and Utah. In my experience dealing with the federal grazing system and Western land use in general, offensive litigation tactics by outside activist groups have served to totally derail business operations. The legal process is a crucially important part of owning a federal lands grazing permit. While it is critical that we maintain the right of citizens to litigate when necessary, reform is needed to prevent that right from being abused or exploited. Federal agencies must be able to perform job activities that maintain protection of multiple use and ensure the intent of Congress during and in the wake of offensive litigation. It is also critical that permitted public land users have a role in any settlement agreements and that federal employees at a local level have input. Unreasonable timelines have become the norm and, once imposed during settlements, are rarely reached. The repercussions of those missed timelines heavily impact permitted public land users and result in a level of uncertainty that is prohibitive in any business environment. Ultimately, this is often the goal of these litigants. I have 2 brief examples of this. The first one is the garbage litigation case based just outside of Twin Falls, Idaho. There was a permit renewal process where a special interest group litigated over the permit renewals. That resulted in an injunction against livestock grazing on 28 grazing allotments. We were able to enter into a stipulated settlement agreement with all parties, requiring the agency to complete some tasks before a deadline of February 28, 2011. Subsequent litigation from the same environmental group, as well as some wildfires, prevented the BLM from completing that task, which resulted in the injunction coming back, and livestock happened to be removed from all 28 of those allotments, while further litigation was completed, which allowed us to return to the grazing allotments just over 80 days later. My second example is with the Endangered Species Act, which was mentioned earlier, that had to do with bull trout habitat on grazing allotments. Although Forest Service was already in the process of reinitiating informal consultation, an outside interest group litigated against it. We, as the permit holders, joined with the Forest Service and were successful in the litigation. However, because of the time that was obligated to litigation, the Forest Service and Fish and Wildlife Service were not able to complete informal consultation before the existing consultation expired. Therefore, before our turnout date in 2017, which was May 8th, the Forest Service called me and told me I wasn't authorized to turn cattle out until that consultation was completed. Those cows are still at the gate waiting to be turned out as we sit here today. The chilling effects of these sue and settle tactics are felt throughout our communities. Not only is litigation expensive, the costs to the communities go far beyond legal costs. While litigation directly or indirectly forces the removal or reduction of cattle, families are forced to make decisions that impact their bottom line and potential ability to continue operations. These tactics also serve to limit young producers from entering the industry, which will inevitably lead to further erosion of the footprint of ranching in the West, as well as open space. As a fourth-generation cattle producer, it is in my blood to continue with my family business. My experience dealing with litigation in public lands gives me pause when considering these options. It is critical that we as Americans maintain the ability to sue our government agencies when warranted. It is also critical that impacted stakeholders have a seat at the table when other parties litigate to ensure our investments are protected and we have some kind of certainty moving forward. But above all, we must ensure the integrity of the entire system by preventing abuse and manipulation by motivated activist groups. The issue of sue and settle litigation abuse is one that simply must be addressed if family ranching operations and rural economies are going to survive another generation. Thank you.
Chairman, Mr. Chairman, ranking members, members of the subcommittees. My name is Kent Holsinger. I'm the managing partner of Holsinger Law, LLC. We're a small natural resources law firm based in Denver, Colorado. We represent clients on matters related to lands, wildlife, and water law. In that capacity, we've seen firsthand the effects of sue and settle. It's an honor to testify on this important matter, and I think one of the most significant challenges in this regard is that we have a small number of radical environmental groups that are gaming the system at the taxpayer's expense. And as a result, we're wasting our scarce resources that could be spent on real, on-the-ground conservation efforts, and that needs to change. Ironically, many of these groups are creating their own problems. As an example, the Center for Biological Diversity and Wild Earth Guardians have been very adept at using Section 4 under the Endangered Species Act. It provides that any person can petition to list a species. But these groups and others, over the past 10 years or so, have started to petition to list hundreds of species at a time. And that's just not possible for the agencies to handle, the Fish and Wildlife Service, NOAA Fisheries. As a result, they miss deadlines. And these same environmental groups that petition then sue over the logjam that they've created. They settle, often over a deadline, rinse and repeat, again and again and again. I'll spend a lot of my remarks on statistics from groups like these. As an example, 2000 to 2009, CBD, 409 lawsuits. Wild Earth Guardians, 180. 2009 to 2012, the same group, CBD, 117 lawsuits. Wild Earth Guardians, 55. From mid-March of 2017, the Center for Biological Diversity has been a party to, filed or co-filed, over 16 lawsuits. Now that number might be wrong. I didn't look Monday or Tuesday or today. It could be higher. We've reviewed federal court records for these groups specifically since electronic records were first kept, beginning back in 1990. These two groups, now Wild Earth Guardians used to be called Forest Guardians in Sinapoo, have been party to over 1,500 lawsuits, most of which against the Departments of Interior and Agriculture, most of which citing the Endangered Species Act as a claim. Ironically, these groups are also collecting grants from the government. Wild Earth Guardians in 2016, $800,000 in federal grants. 2015, $500,000 in federal grants. NRDC, another litigious group, collected $6.5 million from EPA over the past several years. According to the GAO, some 3 organizations are getting about 40%, 41% of all the attorney fees on sue and settle agreements. In one particularly egregious case, NRDC spent about 6 years litigating, in its case against the Interior Department, winning a Pyrrhic victory and remand of a biological opinion and collecting nearly $2 million in taxpayer-funded attorney fees. The regulatory costs, as other witnesses have mentioned, are astronomical. We don't know for certain what they might be because no one keeps those records. That's one of the reasons that the Sunshine Act that other folks have talked about, I urge the subcommittees to support. But these regulatory costs are enormous as a result of the litigation, and reforms are long overdue. Transparency is sorely needed. There need to be records kept about who's filing suit, what sort of settlements they're collecting, who's earning fees and how. These groups are also abusing the opportunity to earn fees under the Equal Access to Justice Act with hourly rates that I've personally seen over $500 per hour. And when these groups, many of them, their budgets dwarf those of the clients that we typically represent, even those in the oil and gas trade associations. So I, again, appreciate very much the opportunity to testify today. I urge support to remove the perverse incentives for litigation in environmental laws, the Equal Access to Justice, the Endangered Species Act, and other federal laws. Thank you.